and welcome back to Attorney Paz's Rants of a Criminal Defense Attorney. This week, I want to talk about discovery issues. So, while everyone may think that the state attorney, they have to timely turn over all relevant, potentially exculpatory discovery material, in practice, this doesn't really happen. So, I'll give you for an example. I have a case that's been sitting on the trial list for 2.5 years, and they've given me videos, they've given me police reports, they've given me statements. Then we get an offer in the case. So we discuss the case, we discuss the evidence, we discuss the weaknesses in the case based on what we have, and then the state makes an offer and the judge makes an offer. In this particular case, the offer was 3 years of incarceration. The client rejects it, it goes onto the trial list. Now it gets called in for trial, and now the state is prepping their case. And what they do as a part of the prep of their case is they start running background checks on their witnesses. In this particular case, there's really only one witness, one eyewitness, one star witness, their whole case. So they run this background check, and it shows that she has really bad impeachment evidence. In other words, she has zero credibility because she has other cases in where she filed false statements. She had charges for filing false statements. None of this had previously been disclosed in the 2.5 years this case has been pending. So now the state attorney had to disclose it because we're on the eve of trial. And having seen it now, the state says, okay, well, I can't pursue this case, so I'm going to drop it and let's make a deal on his other cases. My question is what if he would have taken that deal 2.5 years ago when we were pretrial? He would have been sitting in jail for 3 years on a case they couldn't prove because it took me 2.5 years to get this exculpatory evidence. All of this material is Brady material. It's all constitutionally entitled to you. But the question is, when is it constitutionally entitled to you? Apparently, the judicial process is okay with it only being provided to you on the eve of trial. What if he had been sitting in jail during the entire period? He did do some time in jail, but he bonds it out about a year ago. But what if he had been sitting in jail for the entire 2.5 years and now all of a sudden the state can't prove their case? This is extremely disturbing because now you have potentially innocent people that are sitting in jail for 2 years pre-trial. They're not convicted, they're presumed innocent, and then they are not being presented with exculpatory information that the state could have dropped their case way before that. So that's my rant of the day. Just make sure you understand that when you get all the discovery material from the state, there's probably more that you wouldn't get unless you put it down for a trial and the state actually starts prepping their cases for trial. So if you have any questions about this, please feel free to email me, Brittany@roweneattorneys.com. And as always, take care, don't get arrested, and see you soon.